Hi. Thank you all for being here. I'm Anna Pusey. I'm the Director of Media Affairs and Public Relations at the Federalist Society. On behalf of our organization, it's my pleasure to welcome you to today's Media Roundtable, marking 20 years of Chief Justice John Roberts' service on the Supreme Court. The last 2 decades on the court have produced decisions that have shaped not only the law, but also the way we all think and talk about it. Today gives us a chance to look back at that legacy and its lasting impact, especially as we head into a new fall Supreme Court term. We're fortunate to be joined by a distinguished panel representing experiences in academia, private practice, and public service, scholars, practitioners, and advocates who study the court, teach it, and argue before it. Our goal is to give you direct access so you can ask questions, exchange ideas, and draw on their expertise in your reporting. This roundtable is part of a new Federalist Society initiative to support the press with resources and perspectives on major legal issues and the public policy debates of today. We hope today will be the first of many such conversations. Thank you again for making the time to join us. And I will note that the Federalist Society takes no positions, and all opinions expressed here are those of our experts. With that, I'm delighted to introduce our moderator, Jan Crawford, Chief Legal Correspondent for CBS News, to kick things off.
Thank you, Anna. Thank you guys all for braving the traffic. One drop of rain and it turns DC into a parking lot. I am really happy to be here and appreciate Sheldon putting this together. Thank you. And assembling this incredible panel of really some of the brightest thinkers of their generation about the court and the law to talk about the 20th anniversary of the Roberts Court and how we got here and what that means going forward, specifically some of the cases this term and themes that they see. I'm sure you guys all know the people on the panel, so I'm going to keep these introductions very short, I was told, so we have time for a discussion, and then we'll have questions at the end, because I'm sure you guys will have a lot of questions. I'm just going to try to stay out of the way here and let y'all go at it. But I'll start here with Kannon Shanmugam. You guys all, I'm sure, know him. He is chair of the Supreme Court in appellate practice. You also run the Washington office and many other things at Paul Weiss. Adjunct professor of Georgetown. He's obviously a prominent advocate before the court who, I think you've argued 39 cases and counting. And that, by the way, is the number of cases the Chief Justice had argued before he was nominated to the Supreme Court. So, next to Kannon is Jonathan Adler, a new law professor at William & Mary. He writes frequently about the court, an author, a commentator, and I think if you guys missed this, he was recently cited in a dissent by Justice Jackson, where she called him a knowledgeable researcher. So you could tell us about some of that research that so impressed Justice Jackson. And next to Jonathan, we have Ben Mizer. He's a partner at Arnold & Porter. He was acting Associate Attorney General in the Biden administration. That's the third highest ranking official at DOJ. And in previous administrations, he also served as head of the Civil Division and head of OLC. He's also argued before the court as well. Stephanie Barclay, Georgetown law professor. She's co-director of the Georgetown Center for the Constitution, which obviously is a pretty invaluable resource, as is Stephanie. And she's a constitutional law expert, but I think we could say specifically on religion and First Amendment, those issues. And then last, but certainly not least, we have Professor Xiao Wang. He is the University of Virginia law professor. He's director of Virginia's Supreme Court Litigation Clinic, which has had a really great run at the court. He may get another one. It's on the long conference for this week. And, he did have the distinction of arguing the Ames case last year, which was a unanimous decision written by Justice Jackson. Let's just start with you, if that's okay. We're going to just maybe each of you just take the headline, what you see the headline, as the biggest kind of takeaway or theme at this 20th anniversary of the court led by this Chief Justice. Obviously a very different court than it was when he took over in 2005 on almost every level. What, Professor Wang, would you say is one of your biggest takeaways or headlines?
Yeah, thank you for the warm introduction, Jan. I think in preparing for this panel, I sort of last week, just out of curiosity, looked at the cases that the court had decided right before Justice Roberts came to the bench. So 2004, 2005 term. And I think my biggest takeaway actually was how boring the Supreme Court was back then. I mean, the two or three most notable cases of that term, sort of looking back, were Kelo versus City of New London, which was a huge case at the time, I think in the media, but has generally been sort of a nothing burger given some of the pushback from the state level to eminent domain. And then this other case, United States versus Booker, which had to do with criminal sentencing and the sentencing guidelines. And that's, I think if you practice in criminal law, has also been sort of minimized over time, because now most of the times judges just sentence according to the guidelines. And if they don't, or even if they do, they'll just recite a line from Booker and just go on with their day in sentencing proceedings at the federal level. And you contrast how boring the Supreme Court was in 2005, right before Justice Roberts came on the bench, with what's on the docket for this term already, right? We have the Slaughter case, we have the tariff case, we have the Childs versus Salazar case, several other transgender cases, and I think what I reflect on is during the confirmation hearings, I think most Americans thought that Chief Justice Roberts was going to continue with this boring court, was going to continue with this idea of judicial minimalism. And it hasn't really been that. And I've been sort of fascinated to see how we've gone from what the court looked like, or the cases that it was deciding in 2005 versus the cases it's deciding in 2025. I have a few theories that I'll just provide for maybe 20 seconds, but I know other panelists have other thoughts on why the docket's changed. I mean, certainly one of the big changes is that the court isn't the same court. I mean, every justice has turned over except, I believe every justice has turned over except for Justice Thomas. I think secondly, some of the main cases that I just cited, the more sort of hot button cases, they come from the administration. They come from the party in power. So I think that's certainly a lever. And third, I think part of it is candidly media coverage. I think there's much more media coverage of the court, and some of the cases that may not have been sort of as covered as widely or discussed as widely by the media are. I think every case really sort of gets a headline these days, and I think that makes the public more aware of what the court does. So those are just a few thoughts on my end, but obviously very curious to hear what these other folks have to say.
And that's the great irony, is that when the chief came onto the court, that was something he really made no secret of doing, that the court needs to kind of pull out of these hot button disputes and not be deciding the heated issues of the day. And then instead, it's not quite worked out that way. Thank you. Professor Barclay, I mean, obviously, some people have been critical of this court as kind of retrenching on certain rights and liberties, but they've also made inroads in other areas. Kind of what's your takeaway of where we are?
Yeah, I think that if we contrast like the Warren Court or even the Rehnquist Court before the Roberts Court, those were courts that seemed to be more focused on pragmatism. And so there were some justices that famously would tell their clerks, I just want to be in the middle on this issue, just get me to the middle, which is a pretty outcome determinative, pragmatic approach. And I think we have a court now that's much more focused on methodology. We've seen the rise of textualism and originalism with this court, with the addition of Justice Barrett, and then we have 6 justices who, at least much of the time, are interested in those sorts of methodologies. It's interesting to see that there's some differences in terms of like how those methodologies cash out for them. But I think that is a driving force behind a lot of the decisions and a lot of the changes that we've seen. And so one of the ways in which that has cashed out with respect to rights that you've talked about is I think the court feels like if the Constitution, textually, historically, gives us, the court, a warrant to enforce rights, then we will rigorously. And we've seen the rise of religious liberty protections, both in the context of free exercise, church autonomy with the ministerial exception under this court, I think because they see that as part of the constitutional mandate. And they've whittled away at Smith, which was ultimately, I think, largely a pragmatic decision. The recently released papers of Justice O'Connor show that the court's deliberation largely just involved their discussions about, I don't know, religious exemptions are hard to administer, and there's a lot of religious minorities out there, and it's kind of a pain. Maybe we shouldn't do that anymore. No discussion in her papers about the meaning of free exercise, and the court is much more focused on that now. In contrast, if there's not a clear mandate in the Constitution to protect rights, then I think that is a spot where the court feels like, well, then we ought to stay out of it. We ought to turn this back to the political branches. And Dobbs is an example of that. It has been controversial, but it is absolutely an example of the court trying to step out of hot-button issues and turn that back to the political arena if the Constitution hasn't given that issue to the courts.
And thank you. And Ben, I mean, I think the chief was pretty clear when he said, that was the obvious case everyone worried about in 2005, and then with Justice Barrett's arrival, there was then 5 votes. But what's your take on that? And
yeah, I think for me, one of the major takeaways of his tenure has been the developments in the doctrine of stare decisis. He was one of his first biggest opinions was in his second term in Parents Involved, and that was the sort of school integration case. And that opinion discarded a whole raft of opinions from mostly the 70s related to integration of schools. And Justice Breyer said in dissent, what has happened to stare decisis? Now we see, I think, Justice Kagan writing that in virtually every dissent that it feels like she writes, particularly on some of these shadow docket cases. And I think, I don't want to overstate my case. I think the knowledgeable researcher next to me has written very clearly that if you look at the data, it is not the case that the Roberts Court has overruled precedent at a historic pace, certainly not at least through until Justice Barrett took the court. But I think what matters is really more quality than quantity. And what we have seen in the last 5 years is the overruling of major precedents. You've already mentioned Dobbs, obviously Chevron. Beyond that, some of the biggest cases related to issues touching on race, like Bakke and Grutter, and South Carolina versus Katzenbach was implicitly, if not explicitly, overruled. And so they are landmark opinions that are being overruled by the court. And what matters also is not just what they're overruling, but how they're doing it. I think that they are showing an eagerness to do so with respect to some of these cases. I think Dobbs, illustrated an eagerness to reach that outcome. I think in some lesser known cases, there was this sort of duo of Ramos and Edwards, which Ramos was about the unanimity of jury verdicts. And then the Edwards case was about whether or not that rule then, so in Ramos, they did overrule precedent. And then in Edwards, the question was whether or not that outcome had retroactive effect. And they overruled Teague v. Lane in reaching that conclusion. And if I recall correctly, nobody even asked them to overrule Teague v. Lane. So there's a certain eagerness to get rid of, I think, what they view as the most troubling precedent that's currently on the books. And now we are seeing that happen on the shadow docket with respect to Humphrey's executor. And I certainly agree with Justice Kagan that that's a troubling way to go about reaching these outcomes with respect to precedent that has been on the books for a long time. And I also think that the rigor of the stare decisis analysis leaves a lot to be desired. And all of that is troubling from the perspective of the rule of law, which is what stare decisis is about. Stare decisis is about the predictability and stability of the court, and adhering to precedent helps to preserve, the court has said time and again, its own legitimacy. And so when people start to doubt the stability of stare decisis, then I think the court itself is creating problems for its own reputation.
Thank you. Jonathan, you've got some research on this, I understand. And is that, I mean, obviously that is a part of the narrative, but what is kind of the history show on stare decisis, and how do you kind of confront the argument on the other side that when people don't agree with these outcomes, then it seems like they're doing it more often and in bigger cases?
Yeah, so I mean, I think I'm going to have a slightly different perspective than Ben on this, but I think it's worth unpacking because it is something that we talk a lot
You're
about.
talking specifically about stare decisis.
Stare decisis, yeah, and
Court's
precedent.
willingness to overturn some of these.
So at least we look at the post-war period, the Roberts Court and I've written this up a couple times, overturns precedents at 1/2 to 1/3 the rate in terms of cases per term than prior post-war courts, the Warren and Burger courts being the most aggressive at that. It also seems to strike down legislative acts less often than its post-war predecessors as well. Is that good or bad? Right, that's a separate question, but it is doing that less often. I checked actually, and maybe it is not fully up to date, and I haven't. There's several data sets one can look at for this, but at least according to the one that's maintained by the federal government, the rate of overturning precedent has actually declined since Justice Barrett has joined the court, which is a surprise. It surprised me. Only 5 years, so not a lot of data there yet to look at, but it's gone down. Has been mentioned that isn't necessarily the only thing we care about. We obviously care about the types of precedent. We care about other things. I think there's one change that we think has occurred, which I'm not convinced of, and then one that definitely has occurred that I think is responsible for the way we talk about it. The change, one claim is that, well, it's the precedents are more significant. And I'm not sure that's true, but I'm also not sure what the metric is, right? So is Obergefell overturning Baker versus Nelson more or less significant than Dobbs overturning Roe? I don't know how you measure that. I know that different people have very strong opinions about which of those is good and which of those is bad and which of those is justified and not. And that's something that we can debate, but I don't know of any kind of measure. There are some really tremendously important cases overturning precedent that we tend not to talk about, but that clearly have massive impacts. So Wayfair, for example. I'm not even sure how many people even remember that, right? In terms of like day-to-day living of the average American, overturning precedent so that states can now tax internet sales, well, it's huge. You know, one of the most economically significant overturning of a precedent probably in the last 30 or 40 years. How do we measure that against Chevron being overturned in a way that it's not clear is going to have nearly the impacts on administrative law that I think a lot of the advocates of overturning Chevron want? Like, again, I don't know how we measure that. One thing that definitely has changed, and changed during the Roberts Court, is the valence of overturning precedent. Right? So the first 15 years of the Roberts Court, what we often referred to as the Kennedy Court, the test of whether or not a precedent was going to be overturned was whether Justice Kennedy wanted it overturned. And sometimes that was overturning precedent in a conservative direction, and sometimes that was overturning precedent in a liberal direction, because Justice Kennedy, while kind of more conservative than not in terms of just if you were counting up the cases, there were certain areas, certainly relating to individual liberty and personal autonomy, where we would not have characterized his jurisprudence as particularly conservative, and where he did not worry much at all about precedent. What certainly changed with him leaving the court is, insofar as precedent is being overturned, is almost all, if we can characterize the decisions ideologically or politically, we would say it's being overturned in a conservative direction. And so I think that changes the way we feel or the way we experience precedents being overturned, because they seem to all be pushing in one direction. But in terms of the volume or the number, it's actually declined. If I could, one last little beat on this, last time I had written this up significantly a few years ago, I predicted that this would change, if for no other reason than on a 6-3 court, it's easier to find 5 than on a 5-4 court. That hasn't happened yet. I don't know if that's a function of just the cases haven't been brought yet. The cases the Fifth Circuit tees up for the Supreme Court aren't the right ones. I'm not sure. Certainly the smaller docket plays a role, right? You're hearing fewer cases, there are fewer opportunities. One hypothesis that we'll see over time is that I think when the court got a kind of clear conservative majority, there were a handful of high-profile cases that had been targets of conservative jurisprudence for a long time. We all knew what they were. We all knew what the cases were that would be at risk when there was a clear conservative majority on the court. And they've dealt with most of those. And it's not clear what that next list is, right? It's not clear that there's another list of high-profile cases, that there's 20 or 30 years of lower court opinions and academic scholarship and so on saying this is why this opinion is wrong and this is how you would overturn it and this is what the law would look like after that was overturned, right? We're kind of reaching the end of that, and I think, again, tentative hypothesis, that it's hard to get to 5 votes if you don't really know why it is you're overturning the case and what the law is going to look like after. And I think it was Justice Barrett pointed this out in Fulton, that that's an important concern. And so that if we don't see an increase in the rate at which precedents are overturned, I suspect that's going to be one of the reasons. That's because the clear, easy targets have been overturned, and it's not clear what the next targets are and precisely how you go about overturning them, and it will take time to kind of build up the basis for taking those steps.
It seems pretty clear that they're going to overturn Humphrey's executor, and they've already been signaling that in cases going back even in the Biden administration, you know, when they allowed Biden to fire a Trump-appointed Social Security administrator. I agree. I mean, we all knew that Roe was obviously the case that conservative legal scholars thought was most lawless. Kannon, do you see other obvious targets? Is the court, you know, beyond Humphrey's executor? I mean, I don't see the stomach for New York Times versus Sullivan or Bergefell. What do you think of picking up on that thread? And then also, I'd just like to get your take on what you see as the Supreme Court advocate about this Roberts Court.
Well, thank you for that wonderfully open-ended question. So let me say first of all...
Pick it up and run with it.
So let me say first of all, thank you to the Federalist Society for including me on this extraordinary panel, and thank you to the National Press Club for hosting us this morning. So I want to step back a little bit and perhaps provide some historical perspective. Jan, you were very kind to mention that I've argued 39 cases before the Supreme Court. 38 of those have been in the Roberts Court. My first argument was in the last year of the Rehnquist Court. Actually, Justice Stevens presided because the chief was out getting treatment for cancer. And so, you know, I've had the chance to, I think, see the evolution of the Roberts Court over these last 20 years from up close. And I think that I would characterize the Roberts Court as really having 2 phases. The first phase, I would say, was from 2005 to 2016. And so I think it's important to remember that the Chief Justice came into a court that had been remarkably stable. There had been no changes in the court's membership for 12 years. He was coming onto the court as perhaps the foremost Supreme Court advocate of his generation. He was very briefly a lower court judge. He joined the court at the tender age of 50, and he was sort of coming into this room where this conversation had been taking place for a long time. I think over that first 11 years, I think the Chief Justice was sitting there thinking, I'm not really sure what sort of court I'm going to have. It was a very finely poised court. By the end of that 11-year period, the chief had really become effectively the swing justice on a lot of issues, and the court was 1 vote away from becoming, you know, a much more liberal court where the Chief Justice could find himself potentially in dissent, an unusual thing that really hadn't happened, I think, since Chief Justice Hughes. Or he would find himself with a more conservative court. And of course, the latter is what we got. In 2016, Justice Scalia passed away, and that ultimately culminated in Justice Gorsuch joining the court, and then the series of events leading to Justice Barrett replacing Justice Ginsburg. And I do think that the Chief's role has therefore changed. It is true, and I think this is the prevailing narrative, that the chief no longer has control. If the other 5 Republican appointees on the court want to do something, the chief doesn't have a lot of power to stop them. But I think that the chief's role has been understated. The chief has the assignment power, and he has exercised that quite muscularly in big cases. That's a huge contrast with his predecessor, Chief Justice Rehnquist, who I think was content to give himself the ERISA cases and to leave the big cases to others. This chief, as Justice Barrett recently said, likes to keep the big cases, and that gives him, I think, a great deal of control about how those cases are decided. And that having been said, again, he's not always able to control the rest of the court. The foremost example of that is Dobbs, where he would have upheld the Mississippi abortion law in question without revisiting Roe versus Wade. And I think there, you saw a really significant fracture. The other thing that I just want to mention parenthetically, and I know we're going to come back to this, is that that second era of the Roberts Court from 2017 to the present day coincides neatly with the rise of the shadow emergency interim motions docket. I'll call it the motions docket because that's really what it is, which in turn coincides with the rise of executive orders and other forms of unilateral executive action, really as the primary form of lawmaking in our country with the disappearance of Congress. And that has posed enormous challenges for the court. The last thing I would say on this issue of stare decisis is that I want to take issue a little bit with the attribution, the seeming attribution to the Chief Justice of the majority's view on stare decisis. I actually think that the Chief Justice has long taken the view that it is better to try to narrow precedents than to overrule them. I think he's actually quite allergic to directly overruling precedents. And I think we're about to see a huge test of that in the Slaughter case on the removal of commissioners on the FTC. Remember,
Really? I mean, you think that doesn't that one kind of fit his view that you just knock out a leg here and knock out a leg there, and then it just collapses? How it's very different than Dobbs.
Maybe. If you go back to the key recent precedent in this area, a case I argued, the Selah Law case on the removal of the director of the CFPB, there the court sort of narrowed Humphrey's executor almost to cases involving someone named Humphrey. The court said that where a member of a multi-member commission exercises substantial executive power, the president has to have the plenary power to remove that official. And I remember the first time I read that opinion thinking, this is bad news for those multi-member commissions and potentially even bad news for the FTC, because there is an argument that today's FTC is different from the FTC at the time of Humphrey's executor. So that case may in some sense pose this test of whether or not the court is going to be cute in the way that it approaches precedent or whether it's just going to directly overrule Humphrey's. And I actually think that the foremost example of this during the Roberts Court was Shelby County, where rather than holding Section 5 of the Voting Rights Act unconstitutional, the court came up with this clever way to achieve the same result by invalidating the formula for determining which states were subject to the pre-clearance requirement. I think that's kind of the vintage Chief Justice. The chief, again, rather than coming out and overruling precedents, prefers to narrow them often quite considerably.
Anything that you see in the big voting rights cases, they've got, anything at odds with that? How do you think he'll approach those this term?
Well, the court also has the Calais case, which is a very interesting case on the constitutionality of the Voting Rights Act, or at least that's now what it is about. And I do think that race generally is one of the issues on which I think the chief, has staked out a pretty clear position.
Going back to that first full term of the Roberts Court with parents involved.
Correct. I think that I would say that race and the separation of powers are the two issues on which the chief has fairly clear views, but that doesn't necessarily translate into a greater willingness explicitly to overrule precedents, but there is a clear direction, I think, to the chief's jurisprudence in those two areas.
Why don't you guys all just kind of weigh in here now and respond to whatever you've heard that you find interesting, but I'm curious, though, when we think about the Roberts, when he came in, incrementalism, obviously, was the thing. That was how he was going to kind of limit the power of Justice Kennedy, who, was this human jump ball, and, you never really knew where it was going to land. So if you restrain the court, that would minimize Kennedy's power. That's obviously not at all the case now, and I agree, his power seems to have been diminished with the addition of Justice Barrett. But I wonder if, because now the incrementalism approach really seems to have, can we say, failed, if Roberts himself has made a decision to just start going with the majority more. He got no credit for originalism, the legitimacy of the court, all the goals that he had, perhaps he feels he's gotten no credit for that, and so maybe a better approach is to show the court more united with at least 6, and then he gets to assign those opinions too. Do you see any evidence? I mean, probably not, but I wonder how some of the cases show if there's a difference in approach there, or if that's just doctrinally executive power and race. Those are cases he would have been with all along.
I think that there's some of that. I mean, I think as Kannon mentioned, the desire to be able to write the opinion and to determine what it's going to say is something that the chief has certainly seized that opportunity. And
wait, let me ask one. You know, if you think back to like Trump versus Anderson, I mean, he went beyond what he needed to in that case, and Justice Barrett was the one that said no.
Yeah, I mean, there are some cases where I wonder whether or not the opinions he is writing are the opinions he would have wanted. So, I mean, the area that I've focused a lot on in the context of Chevron, you look at the guts of Loper Bright, 90% of that opinion could have been in an opinion claiming to uphold Chevron, but to narrow it the way Kaiser versus Wilkie narrowed our deference, and in line with a dissent that the chief had written in a case called Arlington. I suspect the reason why the opinion includes the language saying Chevron is overturned is because there were 5 votes for that. And so if the chief wanted to be able to articulate and lay out the way judicial review of agency interpretations of statutes was going to be conducted, he had to give that piece to the other justices. So I suspect that dynamic is occurring in other contexts. Where I think that the chief is still, I think, is somewhat more successful is I do think, and you know, people have probably heard, some folks have heard me say this before, I think that the umpire analogy that we always talk about was less about balls and strikes than about the idea that if you go to a sporting event and afterwards you're talking about the umpires or the referees instead of the players, it was not a good game, right? That you want the game to be about the players on the field. So in his view, policy should be about the political branches. It should be about the executive branch, and in particular the legislative branch and elections and those sorts of things, not about courts. There's a very fair argument that that's a naive view at this point in time, that there is no way to put the cat back in the bag. But I think if you look at the early Roberts Court, a whole bunch of decisions on standing, on implied causes of action, and the like, that are all about narrowing the opportunities for the judiciary to make meaningful decisions that alter policy. And I think we're seeing that same thing on the motions docket, right? This idea that lower courts are doing too much. We're going to scale that back because it's not our place. And it's for the executive branch and the legislative branch to figure that out. Now, depending on what one thinks about a muscular executive branch and this executive branch and a inactive Congress may affect how one feels about that. But I think that's part of the
Interesting. You're saying that some of the stuff that we're seeing in the interim emergency whatever docket is also part of that trying to restrain. I know, Professor Barclay, you had something that you wanted to.
Yeah, but I definitely that I see it, and I think the Trump SG's office has gotten that, and that's affected very much which cases they've brought. Right, they've only brought about one, depending on how you count, 1 in 5, 1 in 6 of the cases where they've gotten enjoined in one way or the other in lower courts. They've only brought that small sliver of cases to the Supreme Court.
Being very strategic.
Being very strategic, and if you go through them, setting the Humphreys executor stuff, I guess, slightly to the side, what they all have in common is that there's a very kind of clear argument that whatever's going on in the background, district courts were a little too aggressive here. They were too quick to find standing. They were too quick to assume that district courts, as opposed to the Court of Claims, should be hearing the case. Too quick to issue or too broad in their injunction. And I think that very much plays to both the chief's particular views about the role of the judiciary and kind of where the majority of the court is on those questions.
Yeah, so I think it's an interesting question you're posing, Jan, in terms of is this court more or less judicially modest? You said that we might look at that and say that this court has failed. This goes back to a question Jonathan was asking earlier, like what's the criteria by which we're judging that? If judicial modesty means overruling cases less frequently, Jonathan's research suggests they're succeeding on that metric. If judicial modesty means overruling cases that are reported widely in the media less. They're failing on that metric, right? The cases that they're overruling are certainly bigger ticket cases. If judicial modesty means trying to say what the law is and not what we wish it to be, which is something that the chief talked about in his confirmation hearings, then I think this is a more judicially modest court in that way. If judicial modesty means trying to maintain the appropriate role of the judiciary within our separation of powers, some of their activity, as Jonathan was alluding to on the motions docket, is relevant for that, trying to rein in district courts that were issuing nationwide injunctions that are going to be less common now after CASA, after the court's decision in that case. And I also think this was a court that felt like there were a lot of problems with precedent that they had inherited from previous courts that weren't as focused on textual limitations on the court or whatever the historical meaning of that text was. And rather than say, well, it's just a runway ratchet, we're stuck with it, even though these are mistakes that we, the court, have made and essentially only we can clean up unless there's a constitutional amendment. I think the court thought in those cases, sometimes not the chief, sometimes only 5 justices thought this without the chief, but sometimes the chief did too, that the modest thing to do is to fix their mistakes and claim error and then remove some of that precedent from the books. Another thing that I think is interesting about the court's incremental approach is that it is true that I think the chief definitely prefers just narrowing precedent as much as he can factually and hoping that we don't have to say the magic words, this is overruled, right? But I also think it's true that a lot of times lower courts aren't getting the memo. Like Chevron had not been cited at the Supreme Court for many years, and yet lower courts were applying it pretty aggressively to defer to agencies. And I think that's something that would sometimes move the court to say, we're just going to say the magic words because they're obviously not reading between the lines. And the same was true with Lemon. The court had not cited that Establishment Clause precedent for decades. It was clearly not really good law at the court, and then they just finally had to say the quiet part out loud and tell the lower courts, stop it, that wasn't good law for some time. There's good reason it's not good law. It wasn't based in any textual or historical understanding of the Establishment Clause, and so now we're going to give clearer direction. And I frankly think probably clearer direction is better if we want more uniformity amongst lower courts anyway.
I actually wonder if Justice Kagan's writings have influenced what you just described, which is to say, the chief has demonstrated a fondness for what she called overruling by enfeeblement. And I think since she started calling some of her colleagues out on that phenomenon, it seems to have faded away a bit, and they now just, as you just explained, directly overrule precedent. And maybe it's not often, but it's significant precedent in many cases. So I think she was right to have pointed out some of what was going on quietly, and maybe it is better from a jurisprudential perspective for it to be clearer and more clearly said.
Can I just jump in? And I think I'm taking it a different direction, but Stephanie, you were talking about how from a judicial modesty standpoint, is the court saying what the law is? And maybe this is a very, very recent phenomenon, but my sense, at least from the public, is that the court is not saying what the law is in these emergency orders, especially in these emergency orders, because they're just these 2 paragraphs that have essentially no reasoning, and whether it's been reported that way or its actual effect, its actual and practical effect, and it's not the intention of the court, but it seems like the public perceives that as the court saying what the law is by not saying anything, and then just having this sort of up-down vote. I'm not really sure. I know that others have thought much more deeply, including Jonathan, about this, but I'm not really sure how to actually square this sort of Marbury versus Madison understanding of courts saying what the law is versus having to act on these quick up-down votes where you don't say what the law is, and maybe all you're saying, to Jonathan's point, is, well, the law definitely isn't that, whatever the lower court did, but we're not going to sort of outline at this particular stage, despite the widespread ramifications, practical ramifications, sort of broader legal principles to apply.
Yeah, can I jump in on a couple of things? And I know we're going to be talking about the emergency docket, and so maybe I'll circle back to Xiao's point, because I do think there's a response to that. I actually do think that that the chief has been successful on one aspect of his campaign platform, which he essentially announced when he became chief, which is this desire to have the court decide cases incrementally, which is to say, I think decide cases narrowly, to decide only as much as the court needs to decide and nothing more. But I think he's been successful only in the lower profile cases in that regard. If you look at the sort of meat and potatoes cases, the business cases that I typically argue, you do see the court often trying to find just the narrowest ground on which the court can achieve the highest degree of unanimity. I think you see less of that in the high profile constitutional public law cases where you have certain members of the court saying this whole area of the law is wrong as a matter of first principles. And even there you see sometimes this conflict between the chief, who has this much more incrementalist, pragmatic approach, and certain other members of the court, particularly some of the other Republican appointees. But in the lower profile cases, I think this happens all the time. Now, whether the chief has in fact attained a greater degree of unanimity, I think is open to question. I think the numbers have actually remained relatively constant on that score. It probably doesn't help that the court is taking fewer cases, so the cases it is taking tend to be the cases that are more contentious. And on Professor Barclay's points about judicial modesty, I agree with everything she said, but I will make the point that I think that the emergency docket, the motions docket, is not helping in this regard, because I think that we have gotten to a place where because so much law is effectively made by unilateral executive action, it inevitably pits the courts against the executive or in contravention to the executive, because we see this phenomenon that we've now seen across administrations of challengers immediately going into court, lower courts acting, and that puts tremendous pressure on the Supreme Court to decide these cases one way or the other. And so I think it's very hard for the judiciary to step back. I'm not sure there's any way for the Supreme Court really to step back unless the court takes the approach that Justice Jackson has advocated, which I think does not command anywhere near a majority of the court, to say we're just not going to act in some sort of systemic way.
Well, that's what, I mean, obviously, and some of you have written about the criticism that the court's getting even from district court judges, right? The court, I think, would say, but the concern is we can't write an opinion. We don't want to be locked in. These are interim orders. They're not final decisions. And I mean, I think Barrett has shown with Casa, Maryland versus King and irreparable harm, that's their focus, that these are policies by an elected president, and it's irreparable harm if the span of litigation takes 3 to 4 years and those policies never take effect. But so what should the court be doing? I mean, what can the court do if they're going to take this position, when they're looking at the factors and irreparable harm, and which they've outlined, but they don't want to lock in to any kind of final opinion?
I mean, I will respond to Xiao then, if we're going to turn to that subject and say that...
Wait, yes, we don't, I think everyone wants to talk about the emergency docket and the interim docket. I'm sure there's a ton of questions. So just take it wherever you want.
I'll offer a quick thought, but I'm eager to hear from the co-panelists on this. I mean, I think you have identified the problem, Jan, which is that so much of the motions docket now is really interim in the sense that the court is deciding what should the rule be while these issues are being litigated in the lower courts. And I think that there are two things going on here. The first is that part of the standard, when you're talking about interim relief, is likelihood of success on the merits. But I do think the court doesn't want to lock itself in by saying, here's who's going to succeed on the merits. And you have the further complication that when the court is deciding these cases quickly, I mean, we all know that it takes the court months now to agree on the reasoning on even relatively insignificant cases on the merits docket. I think even among, say, the 6 Republican appointees on the court, it would take them a lot of time to reach agreement, and I'm not sure that the court is capable of doing that on a more fast-moving basis, even if it wants to. But I think the reality is that, and I suspect that the chief very much has this view, that the court is concerned about lock-in, and really, with very rare exception, we have seen the court really refraining, at least as a court. Sometimes there are concurring opinions, but the court has really refrained from saying anything. I think the other aspect of this that is significant is the sense that the government has almost automatic irreparable harm. And as you say, this traces back to an otherwise obscure order in Maryland versus King, a case that I was involved in.
Oh, you were?
Where the court just said that it was irreparable harm to the state in in an important but otherwise unremarkable Fourth Amendment case of all places. And that sentence has been the source of 1,000 flowers because the early emergency orders relied on that. And, I do think...
The Casa case, Justice Barrett really...
Yes.
examines it.
And I think that the court now sort of starts from the point that, that the thumb is on the scales in favor of permitting policies of the executive branch to go into effect pending litigation in the lower courts. And
Because
in
of
some
that.
sense, yeah, in some sense, I think that's had more effect than the actual holding of CASA in essentially allowing the administration to go forward, at least while these cases are being litigated.
So do you think that the court just has to take it, take this criticism from the district court judges because the people will eventually see that Trump's not going to win on the merits in all these cases? Or do you think Trump will win on the merits in these cases when they finally get to a final decision?
Well, can I just add one thing? I think, the court already has ruled against Trump on the motions docket a number of times. And from conservatives, some of the justices were receiving a lot of criticism for that, including Justice Gorsuch and Justice Barrett. So I agree that there seems to be a thumb on the scale in favor of executive action, at least moving forward until there has been full litigation. But it hasn't been a blank check for certain.
Isn't that also partly attributable to the point that Professor Adler was, and you both were making, that they're being very strategic as well? So the administration is not taking the law firm cases. They're not, the SG's picking cases that they think they can win.
Yeah, I think
that
so.
also then makes it look like,
I think it's a mix, but I also want to say something about the point that some of their orders are just, a couple paragraphs. I actually think that is more modest if we're dealing with rushed briefing where they haven't fully fleshed out the issues, the government hasn't been able to make all of its arguments, and neither has the opposing parties. I think this is a court that knows that the lower courts will read every sentence really carefully and try and read a lot into it, and they want to set it in stone less until there has been the fulsome litigation procedure. So that's one reason that I think they're cautious about saying too much if they have to decide something in that emergency posture. And I do think that it's been interesting to watch how those who were criticizing the court for doing too much on the motions docket during the Biden administration, many of those same critics have said the court needs to be doing much more. We need this court to be much more active on the motions docket. And I sort of feel like the court's damned if they do and damned if they don't on that docket. And a lot of what's going on isn't just the court. It's more aggressive executive action. It's more aggressive district court action. And the court is, in a way, responding to this confluence of events, but we're just sort of putting it all on them, which I think is not a very holistic picture of the dynamic going on.
If I could I think one way to think about what the court's doing here is to step back and look at the way the substance of what the court was doing on the motions docket before Trump, and in particular, and on lower court injunctive relief, right? So the idea that a majority of the court thought that district courts were becoming too quick to issue injunctive relief against the executive branch is something we've known since Winters versus NRDC, which was 2007, 6, somewhere in that ballpark, right? The case about Navy sonar and affecting whales. The court was very explicit and told lower courts to be far more hesitant to issue such relief. Lower courts didn't listen. The issue of nationwide injunctions, the Bush administration asked the Supreme Court to corral nationwide injunctions in Summers. But the court ended up resolving that case on standing grounds, so it didn't need to get to that. And as a general matter, we've had this pattern where the court hasn't had to talk about the scope and availability of injunctive relief in cases that it decides on the merits, because once the Supreme Court decides the case on the merits, the question of the scope of relief washes out, because all lower courts are subject to that. So we've known that was a concern for some time. And if you look at the early rise of this docket, you see a lot of death penalty cases where I think it's fair to say whatever one thinks of the underlying merits, the attitude of the court was, we've answered this question and lower courts are nonetheless granting these habeas petitions and they should stop. And so you see repeated orders from the court telling district courts and in some cases circuit courts to stop with that. And then you see cases like Juliana, this climate case, where I think it's fair to say, well, if one were looking for an example of a district court judge getting out over their skis to an incredible degree, it was that litigation. And the court was very clear, district court, you should not be entering these sorts of orders. So if that's already the posture of the Supreme Court, right, that district courts should be much more restrained in issuing injunctive relief against the executive branch and be much more concerned about the breadth of the relief they're offering, an administration that's being very aggressive with exercise of executive power, knowing that's the orientation of the court, would be stupid to not recognize that creates an opportunity to push back when district courts issue broad relief. I would also note one just little difference between the Trump administration and the Biden administration. It was more often the case during the Biden administration, for whatever reason, that district court orders entering things like nationwide injunctions would then get stayed by the lower courts. And so the Supreme Court didn't even have to enter on that particular dynamic. And in the Biden administration, at least, most of the challenges to things like nationwide injunctions arose under the APA. And I'm one of the few folks that is on record saying that the Biden administration was correct, that there should not be a universal vacator under the APA, but that's a minority position, and I doubt it's a position that 5 justices would ascribe to. The Trump administration has avoided making that argument, right? They went after universal injunctions under the background equitable power of lower courts and has not pushed it on the APA ground. So I think understanding the kind of overall orientation of the court on these questions before the Trump issues were in play explains a lot of what we see, and then what I think has been I should say, surprisingly strategic response by the Trump administration to take advantage of that explains the bulk of what we've seen.
Can I underscore just one thing that Jonathan just said? There is definitely a bipartisan valence to this. I mean, it is really quite striking if you go back and look at the numbers to see the spike in requests for emergency relief from the administration, which started in the first term of the Trump administration, but really continued through the Biden administration. Now, I think there's no doubt that the second term of the Trump administration is going to set the high watermark in that regard before it's all over, and that reflects the unprecedented volume of executive orders. But the Biden administration was fond of unilateral executive action. It often wouldn't take the form of executive orders per se, but which is why the APA, of course, comes into play. But the Biden administration faced exactly the same dynamic, took the position that nationwide injunctions were improper, and indeed took the position on APA vacatur that Jonathan is advocating. And it was surprisingly successful at the Supreme Court, notwithstanding the perception that the court was hostile on the merits. When you look at the numbers, I think the Biden administration prevailed on something like 53% of its emergency applications to the Supreme Court. That's not as high as the Trump administration's success rate, which I think reflects the valence of the court to some extent. But I think it underscores that the dynamic that we're seeing is lower courts, which are often chosen quite strategically by the plaintiffs, enjoining executive policy priorities quite aggressively. And that puts tremendous pressure on the Supreme Court, no matter who's in charge. Because the minute that major policy priorities get enjoined, the administration is going to be under pressure, and the Solicitor General is going to be under pressure to go up to the Supreme Court if necessary. And if they can't get relief at the Court of Appeals level, the next stop is going to be the court. And even taking into account a certain degree of strategic behavior, there's no way that a Solicitor General could say no to all of those requests when the policy people are saying we need to take this all the way. And so the Supreme Court is going to be in the crosshairs whether it wants to be or not. And even deciding to issue executive order, emergency relief less frequently would still be a choice.
I do think, though, that some of the orders on the emergency docket or the shadow docket are putting the district courts and the circuit court judges in a tough spot, because the Humphreys executor line of cases is a perfect example. The lower court judges are still bound by Humphreys executor, and yet we have these unexplained or scant explained orders from the court suggesting that it's no longer good law, pretty clearly suggesting that it's no longer good law, but it's still on the books. So what are they supposed to do? And then they're getting, some judges have been directly criticized by a couple of the justices for not following these unexplained orders. And so I think that the conversation between the Supreme Court and some of the lower court judges is quite unfortunate. And I think it's exacerbated by the way in which the court seems to be saying, look at what we're doing and follow what we're doing, even if we're not telling you why.
So can I politely but completely disagree with that? I actually think that the Humphreys executor issue, which is the issue of removal of members of multi-member commissions, is one of the few issues on which the court has spoken, I think, on the merits in the Wilcox order, where the court reiterated what it had said in the majority opinion on the merits docket in Saleh law, which is this standard of considerable or substantial executive power. And I think it was quite clear in Saleh that the court was narrowing Humphreys significantly. And so while, yes, it's true that Humphreys is still on the books, that is the latest pronouncement from this Supreme Court. And I do think that once the court reiterated that in Wilcox, it was making pretty clear to the lower courts where all of this was going. Now, that having been said, I think you're right that in many, many other areas of law, you have the problem that Xiao identified. And I recognize that it's a problem, that the trade-off here from the court saying less is that lower courts have less guidance about what the court is doing. And often it has to infer, and the court has sort of suggested that this is what lower courts should do. It has to kind of infer from the fact pattern whether a case is similar enough, and that's not an easy thing to do. And I agree that it's unfortunate that there has been this sniping in both directions. I actually think it's unfortunate as well that district courts have been sniping back at the Supreme Court. I'm looking at Lawrence Hurley, who reported on much of this, because I think everyone is trying to do their best here. Like, I actually really do indulge a presumption of good faith. This is a really challenging position for all of the courts, and kind of unprecedented, again, in terms of the volume. And so I think that the courts are trying to find their way in terms of how to deal with this, and that includes the Supreme Court.
Let me just kind of raise one thing, and then you guys respond to this as well. But you kind of are off on an island. It seems like now where we are is people aren't assuming that the court, specifically the Supreme Court, is acting in good faith. And we've seen countless stories and narrative developing, voices on the Hill, that this court is illegitimate, that it's lawless, that it's corrupt. And, you know, I think anything involving Trump, when that kind of helps fuel some of that narrative. I mean, is that a concern? And should that be a concern? I mean, that we're hearing more and more of that? Or is that just part of, you know, people are always going to criticize the court when they don't like what they do, go back and look at the billboards, impeach Earl Warren, I mean, all the things like that. So anyway,
we did
that's
see
kind of
we saw those criticisms die down some when the new Trump administration came in, right? It went from like the court under the Biden administration being deeply illegitimate and talk of court packing to like, help us, Obi-Wan Kenobi, you're our only hope compared to the Trump administration. So I do think that it's interesting to see that it shifts. It shifts a lot depending on what is perceived as the greatest political threat of the moment. One thing that I just want to add really quick to the discussion about the shadow docket, I agree that sometimes it's hard for lower courts to know, like, what does this precedent mean? It's pretty brief. What am I going to do about it? One thing that I think has been beneficial that the court has done that I would like to see them do more often is when they pair a significant motions docket ruling with then putting something on the merits docket where it's like, and we're going to clean it up soon. And I think that's what we see with the Court Slaughter case. We're going to get some more guidance, and you're right, Kannon, we already have a lot on the removal power. The court has done the same thing in Ramirez. They had a series of motions docket decisions dealing with death penalty cases with religious liberty exemptions. They were just kind of ruling willy-nilly about that, and then they just put one of those cases on an expedited briefing schedule on the merits docket so they could just tell us, here's really what we're thinking about this. They did something similar. They had a significant ruling in Tandon in a religious exercise case, and not long after that came Fulton. So I think more of that would be good. If they have to move quickly on the motions docket and not give us a fulsome opinion for a lot of reasons that I make sense, fine, but helpful if they can follow that up with better guidance for lower courts soon.
I was going to say, I mean, I think these are related. On the shadow docket part, and I think relating to some of the removal cases, I do think one of the things that is going on is that the chief and some of the other justices really don't like the idea of simple litigation brought by private litigants being the terrain upon which major policy questions are resolved. And I think you can see this in a whole bunch of the chief's opinions and decisions, even in other sorts of contexts, right? I think that's a way to help understand cases like King versus Burwell and the like. And so in a case like a removal context, right, we have a precedent saying president can't remove without cause, where Congress has said so, at least in certain circumstances. We have no precedent that the federal judiciary can order reinstatement while litigation is pending to allow someone to continue to exercise the power of the federal government as against private individuals and act as an officer in the interim, right? Humphrey's executor was a suit for, by the estate for back wages. Mizer's suit for wages. Employment context more broadly, we recognize reinstatement after the fact sometimes as a remedy. But the idea of reinstatement pending litigation is rare even outside of the separation of powers context. And so I think, and I think you see this in the questions presented that the court set out for Slaughter. I think you see this in Judge Rao's opinion below in the DC Circuit, right? It's a really serious, heavy question whether or not a district court or a circuit court should order the temporary reinstatement of someone that the president has purported to remove so that they can continue to exercise government power as against private individuals in the interim of litigation. Right? Big question. And the court is clearly uncomfortable about lower courts making those sorts of judgments in ways that are adverse to the political branches as opposed to letting the political branches fight it out. I think a lot of the funding cases, you see a similar dynamic, right? Congress has said a lot of the stuff should go to the Court of Claims because that's what the private litigant actually has a right to ask the courts to do. The private litigant doesn't have the right to ask the courts to rebalance the power between the executive branch and the legislative branch. You see this in the court's nationwide injunction decision, right? Private litigant has the right to ask for relief that redresses their injury. They do not have the right to ask a court to impose something nationwide unnecessarily. So I think that's a theme that we see across this. Now, whether or not that's a good posture for the court to take or not, separate question. Justice Jackson has certainly, I think, been the most forceful proponent of a very different view of the role of judiciary and of the view that at this particular moment, the judiciary should be more active. But I think in terms of just understanding the dynamic, I think that's a really important thing to see in terms of what I think the court thinks it's doing. Now, how that affects legitimacy, as an academic, I want the court to write 50 pages every time it does anything because I love poring over the opinions and analyzing and so on. But time-wise, right, writing an opinion that everyone can agree with that actually resolves questions is hard. It's time-consuming. There is a trade-off there. And it's not clear that the opinions that would be produced that quickly would be the better opinions. There is already empirical work showing that the later argued cases in a term that there are various ways of measuring that they are just not as good opinions. They create more problems. You've had justices make this comment about stuff that they do where they have 2 months to work on it as opposed to 6. And here we're talking about days and weeks. And so I think that's a trade-off there. And I think if in terms of the legitimacy point, we're just in an environment where on these sorts of questions, other sorts of questions, each tribe is going to attack the court if the court isn't doing what that side wants. And so when you look at the public opinion, the biggest thing I think you see is not where the court is up-down, right? Because it's still higher in terms of confidence than other institutions. Americans don't like any institutions right now. They just dislike the court less than they dislike other ones. But you see a really big partisan split that is larger than we've generally seen historically. There was a dip in conservative views of the court after the Obamacare decision that rebounded. You saw some partisan difference, but the decline in confidence in the court now is driven almost completely by just bottoming out of views of the court from the left or from self-identified Democrats. And I think that's a function of the partisan environment we're in.
Jan, I think your question was about sort of the fevered pitch of criticism of the Supreme Court. And I don't think that that's new. I think that the Supreme Court has always been the target of very heated criticism. Certainly, I clerked almost 25 years ago in the era of Grutter and Lawrence, and it was a very controversial time then as well.
We can't forget Bush versus Gore.
Right, but I think what is newer is the direct attack on lower court judges, and coming from the President of the United States, attacking district court judges who are presiding over cases that he cares about, and attacking those judges before they've even done a single thing in the case, like the judge who has the Comey prosecution. And I think that is a dangerous development. And I think, therefore, to also have Supreme Court justices criticizing lower court judges for trying to do their job, it's not an opportune moment to join that chorus of criticism of lower court judges who are now having to have the Marshal Service protect them if they enter rulings that the administration doesn't like.
Yeah, I'm going to, again, respectfully disagree a little bit. I think that all of these attacks on legitimacy are of a piece. I've already spoken about the attacks on the Supreme Court's legitimacy, and I take your point, Ben, that the court has always been criticized, and of course, some degree of criticism of the court's work is healthy, but I think the rhetoric around this being a corrupt court has gone too far, and I completely agree that the rhetoric coming from conservative sources now directed at lower courts is similar in that regard, and I think that both are, in my view, unfortunate. I think the harder question, and it's one that I've been thinking about a lot lately, is, why is this happening? And I think one response is that we just live in this incredibly toxic political environment, and all of the rhetoric around all of our public institutions at this moment is very toxic. It presumes bad faith, and maybe it's a Midwesterner in me. I don't presume bad faith, but there's a lot of presuming of bad faith going on out there. But I think that the bigger issue is that, the judiciary is, kind of in this very exposed position in this moment. And I do think that the executive orders are part of it, because when Congress has stepped back, I think the vacuum inevitably gets filled by the other two branches, and that pits those other two branches against each other, and I just think that that's not a very happy place for us to be democratically. But I do think that a lot of the subsidiary aspects of the current dynamic are not helping in that regard. The fact that we have a more polarized judiciary, and therefore plaintiffs can engage in much more effective forum shopping, creates this problem. And we have seen that problem equally before January 20th of this year and after. And I've heard some people try to distinguish between, it's not okay to go to a single judge division. Is that really different in kind from going to a district where all the judges were appointed by a president of one party? No. I mean, this is a dynamic of the litigation that has existed now across administrations. And I think the last thing I would say on the issue of, the removal of power and other separation of powers issues that are coming before the court is that I think one fair practical critique of what the court is doing, and I saw a post as recently as this morning by the great Caleb Nelson, which actually makes this point, is that the court's jurisprudence on this question of the removal of power, I think, presupposes a functioning separation of powers, but the practical effect of that jurisprudence at a time when Congress is absent from the scene is to confer more power on the president in a circumstance where the principal check on the president is the judiciary. And so in some sense, again, query, what the court is supposed to do in that circumstance, because the court's got to figure out first and foremost what the Constitution dictates, but it's just awfully hard to implement that at a time when the Constitution is perhaps not quite functioning in the way that the founders presupposed.
Professor Wang, I'm going to ask your thoughts on some of this, because you had the distinction of a pretty high-level controversial case last term. People thought was going to be controversial. That ended up being unanimous and written by Justice Jackson. When we look at this court now, she doesn't write a lot of majority opinions, certainly not ones that are unanimous. She's really obviously becoming like the lone dissenter often on some of these cases and the positions that she's taken out. And she's, I think, very happy to do that. She thinks all the justices should be writing. That, of course, is at odds with the Chief's approach, which wants the court to speak with one voice. I'm just wondering, from your observation, have you noticed like this a change in language? And is that contributing to kind of the heightened sense of frustration that people who disagree with these decisions are feeling on the court and off the court?
Yeah, sure. I think that when we were preparing that case for briefing and for argument, I had a sense that we could certainly get bipartisan support and that it would cross the aisle, that some of the arguments would sort of echo and be embraced by justices across the bench. But that's not necessarily what was the popular perception. And I guess as a teaching moment for my students, I usually say that in some ways the court, when we try to sort of teach it to the students, we say, look, in some ways the court is like sort of almost a dysfunctional family at Christmas. And they know that there are going to be definitely cases where they're going to disagree very, very, very strongly. And they know there's going to be 6-3 or 5-4. But, you know, even the most disagreeable family wants to agree on some things. You can present them any theory or some theory where there can be some sort of unity or some sort of understanding that, hey, we can all agree on this principle and it can apply in this case and it can sort of be something that we can see can be resolved on these sort of purely legal grounds of precedent and text. I think the court will try to jump at that because I don't think they want to just disagree for the purpose of disagreeing. I certainly don't think any of the justices want to do that. I think certainly they have obviously very different views on specific issues, but if you can present a theory, and then I think we try to teach our students this, if you can present a theory that is grounded in principles that they can all agree on, then they will agree on it, right? And I'm sort of ecstatic that that's what happened in the Ames case. I think what was difficult for me as a litigator necessarily, not just an educator, but a litigator, was that just wasn't necessarily the case with the media and the press coverage. And sometimes I think law students, lawyers, the public are driven by the media and the press coverage for better or for worse, because maybe they don't have access to the briefs or they don't want to read through the arguments or they don't have time to read through everything. And that makes it really tough because I think, you know, when you sit down and you talk to people, at least when I sat down and talked to folks on sort of both sides of the aisle that were not lawyers and really explained the case, I think most people sort of came to a pretty straightforward conclusion that, hey, you shouldn't sort of have this. This was a case about a background circumstances rule. You know, you shouldn't have this rule. But that just didn't get filtered through the media. And I'm not trying to sort of single out any specific media outlet or anything, but I'm not entirely sure that that's something that the court has done or that the litigators have necessarily done, but it has created this atmosphere where it's difficult to teach and to practice and sort of inculcate the understanding that the court is really doing the law thing rather than the politics thing.
So was that case kind of filtered in some areas through like the lens of Trump?
Yeah, certainly. I think
What do you mean?
I think when that case, when Trump got reelected, sort of a month after the case got granted, it all became sort of this case about sort of the end of DEI. And, you know, part of me said, well, I really don't think that this case isn't going to be cited in the executive orders. I don't think that this case has anything to do with DEI. And there are sort of a lot of good legal reasons why. And in fact, that this doctrine arises, for instance, because there's no direct evidence of discrimination, whereas DEI sort of opponents, whether you like it or not, they just say DEI itself is direct evidence of discrimination. So there are many good legal reasons why these two things don't intersect, but it was quite easy, I think, to craft a narrative and sort of a digestible one to the public that they were, in fact, intertwined. And I think we did I hope we did a good job in trying to disentangle that. But, you know, I'm not necessarily on the front lines of trying to speak to the media and trying to sort of change the public perception when sort of we have a job and duty to our client and responsibilities to the court. And I'm not entirely sure sort of how one can really address that, because I think that view to me, or sort of how the media handles certain issues, that's not necessarily unique to that case.
That does show Robert's power of opinion assignments, though, by giving it to Justice Jackson. I mean, I remember when the decision came down, people already had their press releases like blasting the decision, and they never and they didn't rewrite them. So of course, when it's Justice Jackson writing it, they had to pull some of that back. But sorry, Professor.
Yeah, so related to that, I think that in the same sort of vein, there have been a number of religious liberty cases that were unanimous or close to unanimous, but there's just like a major gap between how the court is ruling on the case versus how the media is reporting on it. So it's just an interesting discussion to have in this context. But no offense. So like the Catholic Charities case from this last term with an opinion written by Justice Sotomayor that was masterful. It's a unanimous opinion in favor of the religious group. The case dealing with a religious foster care agency that couldn't place children with same-sex couples was a unanimous opinion. The Supreme Court wrote. And if you had done a ripped from the headlines prediction of what was going to happen, I'm sure if that's all you were reading, you were a Martian who came, you would have assumed surely this will be a 5-4 opinion, and it was not. And in Groff versus DeJoy in Title VII with religious accommodations, it was a unanimous opinion. So I just think that some of what we perceive about the court's illegitimacy or what's going on has far more to do with what we're reading about it in headlines than the actual work that they are doing. That's not to say that there aren't still divisive, heated opinions, but there are fewer of them than I think anyone would think if they just were taking away what they read about the Supreme Court coverage.
Well, I would say, though, I mean, one thing that I think has really changed, and I mean, this is my 32nd year covering the court, believe it or not, we never had law professors writing books that said lawless or having podcasts where they're like using the F word or calling justices, I think has to drive some of the media coverage, is that the language that we're hearing from law professors, and they're just, which if you're not a lawyer, you think a law professor is like an authoritative source.
Yeah, that's... You shouldn't.
No, but they're telling us what the law is.
Right, no,
they're right.
I think this is a fair critique, and I think, like, social
And
media...
I'm not putting you guys in this group. You know what I'm talking about.
Yeah, no, I know what you're talking about. Social media, I think, hasn't been good for law professor dialogue either, and that's not just for their commentary of the Supreme Court. But it is interesting how that has like a polarizing, ratcheting effect on all sorts of rhetoric, and it's not limited to this area. So I agree. We have some responsibility in that.
When we think back to Robert's, and when he joined that court with all these great ideals, I'm really confused when I've seen some of the commentary now, too, is why people are surprised that he's a conservative. It's almost like, he came on the court. It's the straw man argument. John Roberts came on the court and he was promising moderation. And so, in other words, they're saying that, he really wasn't a conservative. But I just don't understand why people are confused. What am I missing about kind of the Roberts we see today? I don't see it being that much different. You had parents involved in 2007, where Justice Breyer puts his hand on his head when in the courtroom when he's summarizing that opinion. That was the clearest sign, I think, of who John Roberts was and still is.
He's a Reagan-era conservative, as you wrote about at the time. And that's somewhat different from a Trump-era conservative, and I think that's where
you see that in some of the appeals court judges and their different approaches now, especially.
Yes.
The Bush appointees versus some of the Trump appointees.
Yeah, I think that's true, but I think, well, let me put it this way. I think one would be hard-pressed to identify a high-profile Roberts opinion or vote that would have been truly surprising to somebody looking forward in 2005. I think somebody would have been quite surprised by the way in which litigation has changed, and if you went back to 2005 and explained this whole executive order world to somebody, you'd probably need subtitles to explain it, because this was so different.
I was surprised by Obamacare.
most of the country. I mean, based on the polling at the time, most of the country was too.
Same. Yeah,
I mean, but just the tax issue, really?
But
But anyway, that was the only one. That's the only one I can think of, not
classic,
Dobbs.
but classic restraint, right, from his perspective. And I don't say that to explain his psyche, but I think that there was probably a healthy dollop of deference to the political branches there, and I think that that's kind of the older school conservative approach. That would be my best explanation for that.
I would say that Roberts' jurisprudence has been consistent. That is to say, I mean, there's a large number of cases where, in service of kind of what I would characterize as a conservative minimalism, Roberts has been willing to take liberties with, be very aggressive with statutory text and the like in order to produce that sort of result. So you can look at Nabudno, you can look at the Wisconsin Right to Life case, you can look at Bond, King versus Burwell. There are a couple others I'm forgetting. Where he is, if the text points in a direction that he thinks is problematic, he has no problems massaging it to produce an outcome that is both narrower and more in line with it. And so from that standpoint, in retrospect, I think the Obamacare decision can be seen as very consistent in his jurisprudence. Not that it makes him less conservative, just that he prefers opinions where possible that have smaller ramifications, right? He wants each decision to be a ripple, not a tidal wave.
Which explains Dobbs as well.
Right. I mean, so that is his preference.
He wanted to knock a leg out from the stool. It was too soon for the stool to fall down.
The challenge, and we're seeing this more and more now, is when that's not an option. Well, of the options that are left, what does he take, right? But certainly, we see fairly consistently that if the chief can make an opinion that way, he will do it, and he won't, unlike some of his colleagues, will not let concerns about methodology and the like get in the way of doing that if he sees that as a possibility.
I'm going to ask one final question, and then you guys just give your final thoughts as well, and then we're going to take questions from the audience. But it's also the 5th anniversary of Justice Barrett, right? And I think, Professor Barclay, you had made the point that her arrival on the court, and you as well, Professor, had kind of diminished some of his influence, So I was wondering if you could all kind of talk about how we should think about Justice Barrett, because I'm feeling much like when the chief joined the court, where it seemed obvious that he was going to be a pretty solid conservative. He might frustrate conservatives from time to time and not swing for the fences as much as they wished, but on the big issues. And I'm feeling that we're seeing some of that same narrative now with Justice Barrett. Oh, she's a squish, or, oh, she's going to drift. And I just curious where there's evidence of that.
Do you want to go down the row, or do you?
However you guys want to do it, yeah.
I have thoughts. So
Go ahead. 'Cause I think this was kind of a point. I'm piggybacking off your.
So I do think that with the arrival of Justice Barrett, the chief had less influence in his ability to sort of control outcomes and also the docket. And I think that's been a good thing, that there's more plurality of views and people thinking thoughtfully about methodology on the court. Let me just mention 2 things in particular about Justice Barrett. I think when it comes, she might be, she's one of the most thoughtful formalists on the court, I think, in terms of being really careful and deliberate about her methodology. And with the rise of what we've seen of history and tradition, I think some of her critiques of her conservative fellow justices have been fair to say, well, which tradition and why? Just because it's old doesn't mean it's originalist and that it's going to inform text. And so you have to have a theory behind the old stuff that you're pointing to, or it doesn't map. And I think she's right about that. And I think that's a valuable thing for her to be raising that perspective on the court, and to also be thoughtful about the fact that, and once we know what the history says, even if it's in the relevant time period, that's not the end of our job. We as judges still have to craft doctrine that is going to implement, or it be a constitutional construction of that history. And I think she's right about that. I think that some of the criticisms she's faced have been unfair, that are coming from the right. I think she does want to think cautiously about the role of the judiciary not being too aggressive, especially on the motions docket in an emergency posture. And so she she's just trying to think about like, how do we weight in appropriately? But on the merits docket, I think all of her decisions can be explained by her methodology. So she's not doing what some conservatives, I think, would describe the chief as doing. They might call it a squish thing that Jonathan was explaining, where he just sort of says, I don't really care about the text in this context. I want to get to the pragmatic, what I see as the modest outcome. I don't see her doing that. I see her absolutely following what she sees as her methodology, really focused on text and history, pointing her towards, but she will be more cautious, I think, about which cases the court grants and when they do those things. And I think that that's probably a good tempering approach generally for all of the different reasons we've been talking about, of the difficulty and the pressure that the court is under right now.
I would just add that I think that I don't think she's actually that different in some ways from Justice Roberts, at least the early days of Justice Roberts. I remember reading her concurrence in Fulton County, where she says, look, I disagree with the principle. I think Smith was probably wrongly decided, but we need to think a little bit more about whether we want to just sort of kick out the whole stool, for instance. And but at the end of the day, the result is I think sort of a result that I think conservatives favor, but as Stephanie points out, everyone signed on to the opinion, but is a result that was perceived that conservatives would favor. And so, in my view, it's one that she's sort of finding her own voice in some ways and expressing it, and maybe she's not pushing as far. But I don't think the criticism necessarily is justified in saying that she's wishy-washy or anything. I think that those are quite different things.
Any final thoughts, and then we're going to take questions.
I mean, I'll just. I think the claims that she's not conservative made on social media or never by some conservative pundits I think are just silly, and it's hard to take them seriously. And I think a lot of those claims also just have not been particularly accurate and detail oriented. I do think one thing that her presence on the court, perhaps as a former academic, and I will confess, as an academic, I like academics on the court. I like reading their opinions. Right, her opinions and Justice Kagan's opinions are both a lot of fun to read, and I don't think that's an accident. I do think, though, that her kind of academic background, her formalism, right? She is not a pragmatic justice. She is a formalist, like most of the conservatives on the court, is likely to over time expose more clearly where a conservative judicial philosophy and a contemporary conservative policy agenda don't necessarily align. And we've seen this from time to time with Justice Thomas. There have been cases, some preemption cases, some standing cases and the like, where he, joins with the liberals on an outcome and then writes separately why he thinks that original public meaning or something else leads in that direction. I think you're going to see more of that sort of thing over time, and that's probably will be exacerbated if we see a continuation of kind of the current political moment of conservatism as kind of the MAGA Trump conservatism, which is very outcome oriented, and having someone that writes the way she does, who's clearly not as outcome-oriented and much more focused on kind of, from a formalist standpoint, what is the proper methodology? What result does that lead to? Can it be done in a coherent way that can actually be implemented and applied consistently by lower courts? We're gonna see some splits there, and it'll be interesting to watch.
Fidelity to the doctrine. What about this term?
In terms of what we're gonna see from her this term?
I mean, splits there. Tariffs?
I've said the tariff case is a toss-up, and because I think that's actually a case where there are currents within conservative doctrine that are at odds, and that are in some respects internal to the doctrine itself. That is to say, the underlying theories about how you read text, about major questions, delegation, and the like, have always recognized that foreign affairs and national security are subject to a different approach. And Justice Kavanaugh said this in his Consumers Research concurrence. Justice Rehnquist said this back in his benzene opinion. You can go all the way back to Curtis Wright. And so it's a toss-up because within kind of the doctrinal context which the conservatives are operating, you see these two things that pull in different directions. And so for me, at least, the question is, do they see it as a foreign affairs case, or do they see it as a statutory interpretation case about the delegation of power to the executive branch? If they see it as a foreign affairs case, the administration wins. If they see it about a traditional statutory interpretation case, they lose. I happen to think from an originalist standpoint, they should lose. But there's 140 years of pretty consistent practice of treating trade policy as a foreign affairs sort of thing where there is broad delegation to the executive branch, and that's hard to undo.
So, you asked us for some closing thoughts. Maybe I'll give a couple. The panel is entitled The Roberts Court at 20, and I think it's interesting, if you had gone back 5 years and we'd done the Roberts Court at 15, and you had asked, what's the legacy of the Roberts Court going to be? I think we would have said it was kind of completely indeterminate then. And I think the irony is that if we were to talk about the Roberts Court in the past tense now, we would primarily focus, I think, on Dobbs, and that was a decision that the Chief didn't join. And I think that illustrates the interesting question here. The Chief is now, I believe, the 4th longest serving Chief Justice in American history. He's now served longer than Chief Justice Rehnquist did. I think the only ones ahead of him are Marshall, Taney, and Fuller, only one of whom really had a great reputation as Chief. And I think this Chief's legacy will in part depend on how much longer he serves as Chief and where the court goes in the coming years. And I think it's entirely possible that a lot of the jurisprudence that will define his tenure will be jurisprudence that he did not completely agree with. And so I think that that is one interesting dynamic here. The other thing I would say is, thinking back to 2005, the court that the Chief Justice joined was very much an institutionalist court. It was a court that really cared about how the court is perceived. I would put Justice Kennedy in that category, Justice Breyer, and many others. And I think that the Chief Justice is very much in that vein, but he doesn't have a lot of partners right now in that regard. It's a much more individualist court, less concerned about how the court and the judiciary more broadly are perceived. And I think that the challenge that the Chief Justice has going forward is in managing this somewhat more individualistic and somewhat more fractious group of colleagues. And I think if you look at the change in the court over time, I think that that's really the big change in many ways.
I just want to say thank you all. This was fantastic. I wished I'll watch it when I get back to the office so I can take notes. That's the only downside. But I can't thank you enough. And I know you guys probably have questions. Josh, you want to kick it off?
Thanks for being on the panel. Appreciate it. So the Chief Justice has used his bully pulpit role a few times, at least twice in the last year. One through his year-end report, where he spoke about, or wrote about, concerns about both rhetoric and especially rhetoric around potential defiance of court orders. And then we saw again in March that he spoke out after the president talked about impeaching Judge Boasberg, and then people have overlooked, made sort of a broader threat that maybe there are a bunch of judges that need to be impeached, and we saw the Chief Justice push back against that. Does anyone on the panel see a tension or perhaps even a disconnect between the Chief Justice's rhetorical stance on those issues and his legal or more formal judicial role in opinions that have come down? I guess critics of his would probably point most quickly to the criminal immunity decision that he authored that basically took criminal prosecution of the president off the table. But I think you could also look at this string of emergency orders that have taken place over the last 8 months or so in this administration and see what many people would say he's not pumping the brakes there, not contributing any constraint to the administration, even though rhetorically when he gets worked up about something, he'll speak out about it. What are the panelists' thoughts on that?
I mean, I'll say, I think Chief Justice has been actually made more statements about criticism of the judiciary, right? He responded to the Senator Schumer comments in front of the Capitol. This year-end report was not the first time he'd raised these issues. I think he's been fairly consistent about raising concerns about when folks have made intemperate or unjustified attacks on the judiciary or threatened the judiciary's legitimacy, and in particular judges, right? He even made comments, I think it was either during the campaign or the first Trump administration, about Trump's comments on the judge. I think he sees, and I would defend the idea that's completely separate from the merits of the various cases. Not a fan of the Trump immunity, many aspects of the Trump immunity decision, but I think that the majority's view was that is the proper application of separation of powers principles. It is the logical implication of cases like Youngstown and Nixon versus Fitzgerald, combined with their general view of executive power. And I think that's I don't fully agree with it, but as a matter of first principle, but as a matter of doctrine, very defensible position, right? If there is a category of things under Youngstown Steel that the Congress cannot regulate or control, then by definition, Congress cannot criminalize them either. And then all we're talking about is what goes in what box. And I think in terms of the shadow docket orders, I would think it would actually undermine the legitimacy of the court for good reason if the court were to approach those cases from the standpoint of, well, what do we think about this president and the broader political environment, as opposed to what do we think about the particular claim made in this particular case brought to us in this posture. And I think on those grounds, I think it's very easy to understand why the courts, given the Trump administration, this winning streak, as I noted before, right, depending on how you count, well, there are over 400 cases filed against Trump administration actions thus far. Depending on how you count, there's somewhere between 130 and 200 or so adverse decisions enjoining or in some way limiting the ability of the administration to execute these actions, and they've brought about 24 to the Supreme Court. And so, if you were to tell me that my client has, well over 100 adverse judgments against them, predominantly in judicial districts that are expected to be hostile to my client's interests, right? Because these are disproportionately being brought in districts that respect that, and I'm supposed to pick 1/5 of those cases to appeal. If I can't get a near perfect winning streak, given that background, then I'm a bad lawyer, right? I mean, if you just in terms of the extent to where these cases are being filed, the one stat that I think is illustrative, right? The first 40 nationwide injunctions against the administration, 35 of them were in just 5 judicial districts. Right? There are 94 judicial districts in the country. 5 of them were responsible for 35 of the first 40 nationwide injunctions. Right? You get that form selection on the front end. You get the ability of the administration to decide which of the over 100 adverse judgments to bring to the Supreme Court, and you have an administration that apparently cares about the talking point of the number of wins they have. I think that does the work, and I don't criticize the court for refusing to engage with these cases on that level, as opposed to on the narrower question of, given the particular relief that was asked in this particular case, given the particular order against the administration, how should we resolve that given our priors on the various factors that should be applied in the context of a preliminary injunction? Right? We can debate whether or not the court's views about those factors are the right ones. Right? There's an academic debate about should an injunction against the administration be considered irreparable harm. Right? Interesting question. But if you start from the standpoint that it is, I think the rest clearly follows, and I wouldn't criticize the court for not being political in how it approaches those things. But
I also think, if I'm not mistaken, there are turtles somewhere on the Supreme Court building, right? Where there's turtles on one of the parapets.
At the bottom of a lot of the pillars,
Yeah.
there's throughout. It's a theme.
Yeah, and that's because the justice system moves slowly and deliberately. And so while we are in a moment when it does feel as if the executive branch is posing a lot of threats to the rule of law, the Comey prosecution being only the most recent example, I think it's premature to conclude that the Supreme Court is not going to do its job. Jonathan just recited the reasons that people are starting to lose hope based on the shadow docket, but I think he also explained why that streak is what it is. And I also think as cases reach the court on the merits, we shouldn't presume that the administration will win them all. I think the birthright citizenship case is probably the one that most people are expecting to be an administration loss. So I myself hope that the turtles are not only a sort of architectural symbol, but reflect the pace of how the court will fulfill its role in the separation of powers.
If the motions docket becomes more preeminent, we may have to replace the turtles with like gazelles or cheetahs or hares, exactly. I would just add one thing. Josh, you mentioned the various statements that the Chief Justice has made. He also made that statement about how there were no Obama judges or no Trump judges, that there were just judges. I'm paraphrasing. And I think that the challenge here is that I think we all recognize the reality that we have a more polarized judiciary, that presidents have set more weight by how they think judges are going to vote when they decide who they're going to nominate. The nominations process itself has become ever more politicized, even at a time when many of us thought that there was no way in which it could. And so you do just have this reality that the identity of the judge really matters, particularly with regard to these sorts of emergency applications. And I know that you all in the press sometimes get phone calls from judges saying, why did you identify me as a Democrat or a Republican appointee? Nowadays, it's a pretty relevant data point. And I think that the chief probably wishes we were not in that world. And again, that world puts a lot of pressure on his court. But that's unfortunately the reality of the situation.
Hi, can you talk about whether you see a difference between how the Roberts Court has treated the first Trump administration and how they're treating the administration so far, and then also do the comparison between how they're treating the Trump administration versus the Biden administration?
So I think, so the stat, and I guess this was Lee Epstein and her co-authors that did this research, that the first Trump administration on the merits did worse than any modern president before the Supreme Court. I think the biggest difference is that we haven't really seen the merits cases yet. And we've seen a very unrepresentative sample of cases and questions on the motions docket. And kind of related to that too, and this is something that flies under the radar, we're beginning to see in cases too, the Justice Department taking actions in some cases that can only be explained as efforts to slow cases down so that they don't get to the Supreme Court, right? So filing en banc petitions in courts where they know there is no chance in the world that the en banc court's going to do something different than the panel did, but it's a way of pushing a case out an extra, 9 months to a year, right? So the removal of the Copyright Office is an example. There's a case in the Ninth Circuit where something like this was done too as well. So I think we really have, the real difference is that we just haven't seen the merits cases yet, right? We're going to begin seeing them now with tariffs and slaughter. Apparently we're going to see them on birthright citizenship, where the administration, I guess, fulfilled, or S.G. Xiao fulfilled his commitment to bringing those cases before the court. All of the real, all the substantive regulatory stuff that I like to spend a lot of time on, right? It's going to be a while before those cases get to the Supreme Court. And so I don't think we're going to have an apples to apples comparison between the first administration and the second administration until those cases get forward. The Biden administration comparison, I think it's more complicated. On the one hand, there was a vision of governmental power that the Biden administration was very embraced, that the court rejects, related to things like the major questions doctrine. I think there was a difference in some pretty high-profile contexts in the way lower courts were dealing with things, right? So you had some pretty outrageous suits against Biden administration executive orders that were, where the district court was picked and the district court went along with it, and the circuit courts corrected the error, so the Supreme Court never had to deal with them. So one example of this would be the social cost of carbon litigation, which I think has a lot of parallels to things like the Department of Education litigation now. And so the Supreme Court didn't have to get involved because the lower courts, the circuit courts got rid of those cases before the Supreme Court had to deal with them. I think there's some strategic differences too, right? You know, the Trump administration deciding to take a clean shot at nationwide injunctions in a cert petition where they expressly did not ask the court to deal with the merits, right? No one had done that. In prior cases where scope of relief was raised, most of the time it would be in the briefing, but not in the questions presented. The few times it was in the questions presented, it was with a case that brought the merits as well. I think for the Biden administration as well, most of those cases also, as I mentioned before, involve the APA, which is just a harder, I wish this weren't the case, but is a harder case to make than the way the nationwide injunction question was presented in CASA. And so I think those sorts of differences matter, and you need more time and a lot more data points before those sorts of differences wash out. So I think, you know, we will eventually be able to do analyses where we have enough data points where we don't have to worry about those sorts of fine distinctions. I think at this point, given how early it is in the administration, you have to realize that we don't kind of have these apple-to-apple comparisons yet.
I'll just add that I would probably flip your question around and not necessarily say how the court is treating a specific administration, but how an administration is approaching the court and what cases it wants to bring and what matters it wants to put on. Because at the end of the day, I think the court is still a reactive body, right? It can't just go out and pronounce law, right? It needs cases that come before it. And I think when you ask your question about the Biden administration, I don't think I'm spilling a state secret that I think the Biden administration consciously tried to keep some issues away from the Supreme Court. And that's why the Supreme Court never got to pronounce its views on certain questions. Whereas I think that perhaps during the first Trump administration, there was some of that, but given the shift in the makeup and the shift in some of the ideology and the shift in the outlook in certain justices, it's been, at least so far, a little bit more aggressive and assertive and muscular. But to Jonathan's point, it's still an open question of when this actually gets briefed on the merits and heard on the merits, what is the final decision? And I think certainly on some of the administration priorities, such as birthright citizenship, it will probably, I think many scholars and commentators probably think it'll not go the administration's way, even though the preliminary order did go the administration's way.
Yeah, and so related to that, like there are some issues that I think the court has been consistent on across administrations. Like the court has been signaling, as Kannon pointed out, for some time its concerns about limitations on removal power for the executive. And so there are reasons why the Biden administration would not want to bring those cases to the court and why the Trump administration does. There's just different policy positions on that across administrations. I think that you're probably right that I think that the Trump administration will probably face some uphill battle on its approach under birthright citizenship. And I think that the jury is still out on a number of different cases that are going to be, as Jonathan points out, coming to the court on the merits docket for the Trump administration.
The Roberts Court has decided a number of high-profile cases on gay rights and transgender rights over the 20 years, some mixed outcomes on those. But I'm wondering if you guys see a difference in how his court looks at sexual orientation versus gender identity. Is there a difference there? Does it matter? And where do you think we're headed this term with the handful of cases involving those issues?
I'm not sure we know yet, because I'm not sure I don't think Scrimetti got deeply enough into those questions for us to know. I think if I had to predict the outcomes, at least on the sports cases, I assume that I think most people assume the court will do something similar to what it did in Scrimetti, although I don't think it has the kind of the out. It doesn't have some of the outs that it took there. But I think the outcome is the same. I think the conversion therapy case I think is more complicated because it intersects with other doctrines that the justices I think have clear views on that complicate it, right? So how to think about whether professional speech is a separate category of speech regulation and so on. But in general, I think the court is indicated it's less sympathetic to those claims, less sympathetic to the idea that sexual orientation or gender identity or transgender status is the sort of thing that should be subject to heightened scrutiny. You know, we don't have 5 justices saying that explicitly, but we have several that have said that. You know, whatever one made of Justice Kennedy's jurisprudence there, since he was really the driving force in the early Roberts Court on those questions. And, you know, academics often lamented that, you know, he didn't put things in the nice little neat doctrinal boxes that we like to see to kind of, you know, so we can explain them to our students. There was clearly a concern that Justice Kennedy had for the treatment of gay individuals and for, you know, individuals who, as a consequence of their sex, their sexual orientation, their identity, were faced discrimination or were treated differently, and the court does not is not as focused on that, and I think that we'll see that in these cases, and I think there are some others in the pipeline. One thing I'll just flag on this, which I think is just worth noting, because it comes up in this context, but it comes up in some other areas like the Mahmoud litigation. There is, in my view, this elephant in the room in a lot of these cases that the court is staying very far away from, which is, what do we think about parental rights, right? Because on the one hand, the court has been very dismissive of or skeptical of the idea that there are unenumerated rights, right? Rights that aren't expressly identified in the Constitution that should be treated as fundamental. On the other hand, there are both historical arguments and certainly are arguments within conservative scholarship and jurisprudence that parental rights perhaps should be an exception. And so the court does not take the parental rights claim in Scrimeti. It has, you know, in any of the conversion therapy cases, it takes one that does not have a parental rights claim and is solely about the rights of the service provider. For the sports cases this term, there's no parental rights claim. In the Mahmoud versus Taylor case, the court ends up making that a religious claim, a religious rights claim that the parents have, not a parental rights as parents claim. And I'm not sure how long the court can do that, given that there is such a wide array of cases that and controversies that affect the extent to which parents should have control over the way their children are raised. And I think one of the reasons the court perhaps is staying away from it is that, depending on whether the case comes from a red state or a blue state, the ideological valence of the underlying claim is different, right? Is it a parent wanting to give their child conversion therapy, or is it a parent wanting to give their child gender-affirming care? And I think they don't really know I don't think the justices know what they would do with that collectively, and so I think they're afraid of that claim, but ultimately they're going to have to confront it, and that will have a big impact on these areas of law.
Let me just add to a little quick follow-up to Devin's question, if that's okay. I think the other big elephant, so now we get 2 elephants in the room, though, it was in the wake of Dobbs, and, you know, Justice Thomas's concurrence, what would this court do with the issue of same-sex marriage, and would they see those issues similarly? And I think that's something that has really kind of underlies some of these other cases have nothing to do with it, but there's that concern or that fear.
Well, I also think that there's the Bostock opinion that kind of threw off some folks who thought, oh, this court, even post-Justice Kennedy, is going to be more amenable to claims by LGBTQ groups or individuals. And we saw with Scrimeti how much that calculation was erroneous. I also think that Masterpiece Cake Shop is a significant signal that where claims of LGBTQ equality meet claims of religious liberty, the gay rights groups are going to lose. Sorry,
No,
and I'm sitting next to an expert on these issues, so I will yield my time.
No, I agree with a lot of what you're saying. So, Jan, to pick up with what you're talking about, in Obergefell, where the court is protecting LGBTQ rights, the court also talked about how, but there are religious people of good faith in our country who still have traditional views about marriage. And in many ways, both Masterpiece and Bostock were sort of like the fulfillment of the other half of that promise. Like we said we'd protect LGBTQ rights, we did in Obergefell, we have in Bostock, but we're also carving out space for speech and religious protection of those who continue to hold to traditional views about marriage. Bostock also talked about how, remember, we have this super statute, RFRA, that will provide protection in a lot of these contexts, which was, again, the court signaling sort of this balance, this deal between these two interests that were important. And so it's not surprising, I think, that following those two cases, in Fulton, a case that dealt with the confluence of same-sex couples who wanted to adopt versus religious liberty rights, in Mahmoud, schools that wanted to read books to children about LGBTQ individuals versus religious parental rights, and now Childs, I'll talk about Childs in a minute, but in those two cases, the court was willing to protect, sometimes unanimously, I think what were pretty modest views of the religious individuals. Because in Mahmoud, they weren't asking the court or the school to change the curriculum. They were just saying, can we just have notice to pull our children out, which, by the way, every other school district in the country would let us do. I don't think Childs is going to be that controversial. I predict a 6-3 vote in favor of the counselor in that case. So this is a counselor who wants to engage in talk therapy with clients who have come to the counselor and said, for example, if it's a client who's suffering from gender dysphoria and doesn't want to feel that way and has said, I would like to feel comfortable in the body I was born in, can you help me? That's the type of talk therapy that Ms. Childs wants to offer. The court has already signaled quite strongly in NIFLA and other cases that it's not going to treat medical speech as second-class speech under the First Amendment. And the state hasn't been able to marshal a single evidence that that type of talk therapy would be harmful. Everybody agrees that the other sorts of therapy in that case, that could be prohibited under the law, shock therapy or coercive therapy, no one is advocating for those sorts of things, but there's no evidence that the state has marshaled that this type of talk therapy with client-directed goals would be harmful. And so I think the state's going to really struggle. Colorado might be continuing its losing streak when it comes to these First Amendment cases that are being brought where they haven't been very accommodating of those sort of First Amendment carve-out spaces in the context of LGBTQ rights as well.
Thank you so much.
We started a little late. Is there one more? Because I know we...
I'll try to make it quick. Kalen Diaz for the Washington Examiner. I just wanted to ask this panel real quick a question about something we haven't talked about a couple years, but one of the most tangible aspects of Robert's legacy beyond his rulings in that matter involved the ethics code that we saw formed a couple years ago. And I'm curious now, it being his 20-year legacy, is this something that we will be able to know in a matter of a decade, looking back on it, how much of an impact it had on this court and whether there's any ill-intended consequences that might have come from it? It seems like it was a topic when the Democrats had a majority, and I don't know the next time it'll become a politically convenient thing to discuss, but I am curious though, because now we have a author writing, I believe Elisa Graves, saying that Roberts maybe should have recused from the case during the Bush administration about the brother of Osama bin Laden, the driver, and whether he qualified as a prisoner of war under the Geneva Convention. That is a new claim that's being brought out in this book. And I'm just wondering if, looking back, if there's ever going to be sort of a regret about trying to bring this ethics code into the foray, if it's not even something that can really be enforced. Like, what's the point, other than maybe giving partisans a tool to attack?
I mean, I think that the kind of the bigger thing that we're seeing is that, again, from a generational standpoint, I think part of what we saw is that some of the older justices that kind of came of age as judges in an earlier, simpler time when you didn't have social media, and kind of aware of what the norms were in the mid to late 20th century in terms of judges' interactions with other folks, who you were in a poker game with, or, did you get to go to the White House to talk about, Vietnam with the president, even though you were on the Supreme Court and stuff. I think we've seen generational changes in kind of what's considered appropriate or what creates an appearance problem. I think that the justices on their own are changing their behavior so as to, if nothing else, spare themselves the grief of the attacks and criticisms that they get on these fronts. And I think that's occurring independent of the code. I think the code was kind of a symptom of the fact that they realized that I don't think that any of the justices currently on the court or recent justices that engage in similar behavior, like Justice Breyer and Justice Ginsburg, did anything that actually compromised their votes. And I think the more you know about the justices on the court, the idea that Justice Thomas is changing his views on a case because he went on some trip is just kind of silly, right? Justice Thomas has very defined, secure jurisprudential views. They are not being influenced by his social life. But I do think the justices have become more aware that given social media, given the fact that there are partisans on all sides of everything that want to find scandal about those who they think are on the other side, that they have to live their lives differently. And I think we will see that the Roberts Court, we will look back and see that the Roberts Court was a period of time when those changes occurred, and that there was a period of time when kind of the expectations and what could be made scandalous and what the justices were doing didn't quite align. But now we're seeing justices become a lot more cloistered, a lot less willing to be in broader audiences, be in certain contexts. I think we lose something from that, but that's a definite shift that I think we're seeing from the justices' own behavior.
I would just add, to close on a completely pessimistic note, that in addition to the ethics issues that have been raised, I think perhaps as a result of the overheated rhetoric around the court, there are really significant security concerns. I was with a Supreme Court justice last week, and I was really struck by the incredibly increased level of security that attends any Supreme Court justice now, particularly when they're away from Washington, which is a huge change just in the last few years. And so the justices are just not out and about as much, with the conspicuous exception of book tours. And I don't think that that's a desirable development, because the justices now are really living in a bubble, and they really have no choice in that regard. And so I do think that that's one, consequence of all this overheated rhetoric, when we've obviously seen the threats of violence against justices, most notably the attempted murder of Justice Kavanaugh. And of course, that case remains pending, but the indictment of an individual for that. And that's just reflective of the times in which we live.
Anyone else? I guess we've gone a little over time, but we started a little late. I just wanted to, you've got one more? Go. If it's okay with you guys, we've got to.
I have to bill my time, but I'm happy to answer the question.
If it's an option, sure, I'll go quick.
Well, why don't you guys both say your questions, then y'all can just play off of it. So.
Sure. On the topic of the emergency docket, I was just curious in the panel's thoughts or critiques on the liberal justices' dissents, perhaps what they're trying to communicate, whether you're seeing any theme in terms of what they're trying to communicate on their dissents on the emergency docket. And then secondly, looking ahead, do you see any practical effect on the acceleration in that docket having any impact on the upcoming term? Whether it'll start to intrude in the justices' time, relationships, things of that nature.
And then can we get your question? Oh, okay. All right.
I've said earlier, Justice Jackson in particular, I think, has been articulating a different vision of the judiciary than I think is shared by the majority of the court, in terms of, right, the majority of the court much more focused on specific litigants make specific claims, and as a formal matter, that's what we resolve. We resolve disputes. We don't merely pronounce on the law. Justice Jackson viewing the court as needing to play a more muscular role within the separation of powers, particularly at a time in which the executive branch is acting in a more muscular fashion. So I think, particularly for her, you're seeing that kind of alternative vision being articulated fairly consistently and aggressively. I think Justice Kagan and Justice Sotomayor's comments I view as being more kind of case specific. Justice Sotomayor more focused on kind of the equities of certain types of cases, and Justice Kagan more concerned about the kind of the process and concerns that arise in certain cases. So I think that each of the liberal justices kind of has their set of concerns that they raise when the particular case hits those buttons, and I think that helps us understand kind of what some of the divisions are on the court. In terms of effect on the court, and Kannon could speak to this from his, well, both Kannon and Ben could speak to this from their experience. The motions docket and emergency orders have always commanded a disproportionate share of time for the justices, and the explosion of that what we're hearing is definitely affecting the justices' perception of their workload, and is probably one reason why the docket is remaining at its ridiculously small level. Right? I mean, I'm someone that thinks that the docket is they take way too few merits cases, but so long as they have so much going on the interim docket, I don't see that changing.
The book tours are still happening, though.
I clerked at a time when Justice O'Connor was constantly complaining about why they weren't granting more cases and was eager for them to grant more cases. Now they grant even fewer. And so I don't think that they're struggling to get their work done.
Yeah, so having clerked at a time when the emergency docket or the motions docket was alive and well, I do think that it is a reason that we won't see the merits docket get a lot bigger. It's just a very heavy workload. I think there's an interesting dynamic between the motions docket and the merits docket. I mentioned before a couple cases that ended up sort of leading to another case on the merits docket. Another one that comes to mind is SB 8, the case that was challenging Texas's law that allowed private enforcement of their abortion prohibitions. And that started as a motions docket case, and then it moved to the merits docket in sort of an expedited way. And I imagine we're going to maybe see more of that moving forward. I also think it's interesting as a litigant, there's a lot of incentives to try to do the motions docket instead of the merits docket, just in terms of how those procedures are set up and the ways in which you might get more visibility on your particular petition. And so I wonder if at some point the court's going to rethink some of those procedures to shift ways in which some of the presumptions or defaults operate for the different petitions coming in, just to change some of those incentives. You could imagine a world in which at some point that happens.
Let me just ask with one final question, then we'll end it here. Is there also, when you think about kind of the internal dynamics of the court, Justice Jackson has come on, and when Justice Alito came on the court, he made a conscious decision to not ask any questions, hardly at all, his first term, because you don't move into a new neighborhood and tell people what color to paint their houses. Obviously, Justice Jackson has not taken that approach at argument, and it's clear that she believes that she should be writing a dissent on almost every case. Is there a concern among the liberals, specifically Justice Kagan, I would think, or do you see that might have unintended consequences in the internal dynamics, causing some of the, maybe, a Barrett or a Kavanaugh might have been potentially a gettable vote for Justice Kagan?
I think one of the most notable trends has been Justice Kagan's seeming reluctance to join the separate opinions in which the other Democratic appointees are casting aspersions on the good faith of the majority. I think that is not accidental.
And I think Justice Kagan probably doesn't love that dynamic and doesn't think it's very helpful for the overall arc of the things that conservative jurists, or not conservative, excuse me, progressive jurists are probably concerned about. I don't think that dynamic helps that cause.
Justice Gorsuch also was very vocal his first term on the court, and in that respect, Gorsuch and Jackson are outliers of the normal practice of new justices being much quieter. In terms of the dynamic, I've heard it suggested by others. Actually, Kannon and I were on a panel recently where another panelist suggested that historically most of the justices kind of viewed the court as their family and their kind of their primary social network, and that the hypothesis was put forward that Justice Jackson, both because she was already here in DC, had been here for a long time, has her kind of community here, doesn't really care about that aspect of the court, and so therefore is less constrained in her opinion writing or not. So I don't know if it's true or not, but I mean that I've heard that hypothesized by someone. She's not the only justice who's come to the court after a long life in the DMV. I agree. I'm just saying it's an interesting hypothesis about kind of that she's just not worried about upsetting her colleagues and therefore isn't trimming her sails for that reason. It's an interesting hypothesis.
Well, Justice Thomas just said, I think, on a panel about how close he was to sort of other members of the Rehnquist court, and implying that's not as true these days. Setting rhetoric aside, I clerked for for Justice Stevens, who wrote separately in virtually every single case. So the fact that Justice Jackson's writing so much is not necessarily a bad thing. Justice Stevens always thought, you know, I'm here to do my job and share my views. But Justice Stevens never used hyperbolic rhetoric.
Right, it's more the tone of some of the writings than the writings themselves. I think that's right.
All right, well, we're going to end it there. Thank you all so much. I look forward to, you know, just staying in touch with you and seeing your comments throughout the term. It's going to be a pretty exciting one, and I think we all are wiser because of your contributions. So even though you have frustrations with the media sometimes, please keep talking to us. Thank you so much, and thank you guys all, and thank you, Sheldon, for organizing this, and Anna, it was really great. Really appreciate being here. Thanks so much.